Shri Vijay Reddy ji.
Thank you, Vice Chairman, sir. Sir, it is well appreciated that it is an institute of national importance, and when compared to the Parent Act with that of the Amendment Bill, the Parent Act provides for only domestic arbitration and conciliation, whereas Amendment Bill provides for other forms of alternative dispute resolution in the manner specified by the, to be specified, not at specified. I'm answering this question. To be specified by the central government through regulations. I expect Honorable Minister to specify the regulations at least in the near future. Sir, I have 4 suggestions to be made to the Honorable Law Minister in this regard. I suggest that government should ensure minimum judicial interference and maximum institutional autonomy. Sir, in the ad hoc arbitration, the parties are unable to mutually agree on an arbitrator. Section 11 of the Arbitration and Conciliation Act 1996 empowers the Supreme Court or High Court to appoint an arbitrator. However, the biggest problem in this regard is the courts take several months to appoint an arbitrator, thereby it results in substantial cost to the parties. Sir, this defeats the very purpose of arbitration. It meant to be fast, and since it meant to be fast and cost-effective method of resolving the dispute. Sir, interestingly, Section 11 of the Arbitration and Conciliation Act also empowers the Supreme Court and High Court to delegate the function of an arbitrator to any person or institution. That is the existing act. However, in the past, if you see the past, not a single case where the Supreme Court or High Court empowered or delegated the power, and it is hardly seen in any of the courts. Hence, I suggest that International Arbitration Center should be designated as default institution. Can't be in the hands, completely in the hands of Supreme Court or High Court, or as the case may be. For appointment of arbitrators in ad hoc arbitrations, I'm talking about the ad hoc arbitrations, sir. This has already been done in arbitration-friendly countries like Singapore and Hong Kong. This will ensure minimum judicial interference and maximum institutional autonomy, sir. This is one suggestion. The second suggestion, sir, which I would like to make is problem of having the retired judges as arbitrators. This has to be addressed. Sir, the worrying trend that is emerging in India's arbitration is an arbitration landscape where the retired judges are largely appointed as arbitrators. Why? Why only retired judges? I'm not saying that serving judges. Rather, I urge the government and the law minister to promote the growth of arbitrator community in India like judges community. Why? See, the dire need to ensure the arbitration in India does not amount to mere post-retirement opportunity for judges. That is not the intent of the act. Sir, these retired judges are running like these retired judges who become the arbitrators after retirement. They are conducting the arbitration proceedings like court proceedings. This would not be correct. This would be incorrect to say that today's judge after retirement becomes the arbitrator after retirement. This is the present trend in this country, sir. So this has to be addressed by the government, sir. So the third suggestion what I would like to make in this regard is skilled human resource. Sir, concerns have been expressed about the arbitration center lacking expertise required for its effective functioning. Sir, the rules issued by the center under the Parent Act do not prescribe. Parent Act do not prescribe arbitration experience. Arbitration experience as mandatory experience. Now, for the appointment of counsels, even though they are required to deal with the matters relating to domestic and international arbitrations, I suggest the honorable to the government that the arbitration experience should be made mandatory for the Council, sir. In the nascent stage of development itself, I hope the government will ensure qualified professionals are engaged in the arbitration center rather than what I have stated just now, sir. Sir, the fourth suggestion what I would like to make is lessons from the Singapore and Hong Kong. And in the case of arbitration, many parties who have got money, they prefer to go to Singapore or Hong Kong or London. Why? Why not India? Sir, our Asian neighbors like Singapore and Hong Kong have become top arbitral destinations due to their immense financial and infrastructural support they got from the government and the balanced approach. Sir, on the other hand, because please see the figures, sir. In 2020-21, we have government allotted only 1 crore to the arbitration center. In 22-23, it has raised it to 3 crores. I urge the government and the law minister to extend the adequate financial resources for the development of arbitration center so that this can be emerged as India's international arbitration center, sir. So there is no doubt that this bill will give a loud and clear message to the international community about India's arbitration-friendly environment. Therefore, with these suggestions, we support the bill. Thank you very much, sir.
Thank you.